Sexual Offences Act is a very good act. When it was enacted in 2006, the challenge we faced that time was that Kenyans felt that sexual offenders were not being adequately punished for these heinous offences that they do, including rape and defilement. Now, over time, we have realized that though it's a good act, in offences relating to teenagers, that's where we have had a bit of injustice. And that is something which, even if you saw the interview of the judge on Monday, Justice Chitembwe, is something that came out. And even today, there's a scholar called Jill Cottrell. She's writing a report in the Star on the challenges of that law. The challenges basically arises whereby teenagers experiment when they try to discover their sexuality. And some of them go overboard. And that's why we have teenage pregnancies and such. But most of these relationships, to use a word, they are more or less consensual. Though the law does not consider a girl or a boy who is less than 18 years to have capacity to give consent. But the social reality is that these things happen. Now, when it is criminalized, it creates another injustice. Because now we are having young men in prison. And you know, the way this law has been enacted is that when a young man and a teenager boy and a teenage girl have sex, you can call it consensual. It is the boy who's punished and the girl is not. And yet, they did it together consensually. So that disparity has created some level of injustice whereby you are now having many young people in prison who have been jailed because of that issue of defilement. But I have to clarify this. It is sex between teenagers that is causing injustice. Where you have a 25-year-old having sex with a 15-year-old, that is unlawful. And such person should be punished. Where you are having even this 16-year-old having sex with an 8-year-old, that one cannot be countenanced. That should be punished. So we are only talking about these people where the age difference, the girl may be 14, the boy may be 16. The age difference can go to a maximum of 4. That's where the injustice occurs.
Dr. Kirui Janet, I'm the Vice Chair of the Power of Mercy Advisory Committee. And just one contribution that I would want to make on the issue of the sexual offenses. And this one is coming practically from our own experiences during our field work when we are interviewing those who have applied to be considered for mercy. We have discovered over and over again that one of the contributions that have made the teenagers to participate in these sexual offenses is one, ignorance of the law, and then secondly, most of these experiences are powered by developmental reasons. Most of them are young and not engaged properly in the community. And then thirdly, some of them are engaging in these sexual offenses because of cultural reasons. Some of the cultural structures encourage some of these practices to be done as a way of proving maybe manhood. Like in one of the communities we went, one of the convicts said that he was only performing what the elders had trained him to do during the initiation period. So that is my experience, and I think it's important what the judge has said, that we relook at this sexual offences act from that causative position. Thank you.
You know, for a lay person, he or she does not understand why you would want to maybe free a convict, a person who has probably done murder, a person who has done robbery with violence, defilement, name all the capital offenses, cattle rustling. A person would not understand. But we are in the Bible, we are told that God made man in his image and likeness. So you can, they are important, our brothers and sisters who have probably reformed, who have undergone rehabilitation in our corrective institutions. They need to be reintegrated back into the society. And when they come back, probably did not have means to start their livelihoods afresh. Because again, they have to start from the scratch. They might be rejected by the community because, there is a negative connotation that this was a convict. This is a bad person. They do not believe they have reformed. So it's not an easy task. So again, they have to be accepted back. They have to be assisted to start livelihoods afresh. So it is not that easy. But I'm happy that the team that is doing this work is a team that is all inclusive. We have all the experts, legal experts, officers from the probation department, from the prison, from the law enforcement agencies. Just like I mentioned earlier in my office, we always want to ensure that there are no cases of abuse, there are no cases of corruption, so that it's only the very deserving ones that are released to come back to society. And we will continue to supervise them to just ensure that they have really reformed and that they will not go back to crime, because there is something called crime recidivism. I can't mention it properly, because there are those who normally like jailbirds who do always, when they immediately are released, they commit another crime, then they are taken back to court and to the prison. So we must ensure that the group that has been released, again, does not go back to commit another crime. So with a multi-agency approach, I think we'll ensure that the team that is released is the correct team, and this other team that will not give problems to the community.